Hi there, my name's Alan Cowgill, and I'm excited to bring this training to you, long overdue, on the changes that the SEC has made, enabling us to advertise to private lenders. And critical information. I get asked a lot from my students about this, obviously, and in fact, just within this last week, a national speaker uh, got a hold of me and wanted to know what the rules were. So apparently his students were asking him. So grab a pen and a paper. I am going to cover a ton of training today, so let's just get started. Uh, One of the things that happens to my students is that when they find that they can go attract private lenders, or even before they meet me, they hear through their RIA groups that they can get private lenders. What happens is many times they jump out and they start to advertise. Well, that's a no-no. There's times you can advertise and times you cannot advertise, and you cannot go out and advertise unless you take some steps. So this training on the new ability to be able to advertise to private lenders is going to be critical to many of you. And along the way, it's the way to cross state lines, pool money, and amass millions and millions of dollars. Now, you cannot just start advertising. You have to ask for permission from the SEC before you do that, and you need to follow their rules on. And the rules are easy to follow. What happens though is most real estate investors are just have no clue on what they are. So, also to encourage you to get this training, I've decided to give you a free gift. So at the end of the talk, I'll have something for you. Just so for those of you that don't know me, I was out in the corporate world. I got a quarter century in corporate America. As I was climbing that corporate ladder, one day I realized I had the ladder against the wrong wall. I heard that 92% of the population retire at poverty level after working a job all their life, and it got my attention because I'd actually seen that happen to some of my family members. Even though I'd been successful in corporate America, I was living in a little dinky two-bedroom apartment, struggling paying my bills. Had a car that needed to have some work done, but I was too busy paying my other bills, and I thought it could wait. But one night, I got embarrassed. I was out on a first date with a lady, parked in front of her apartment complex, started to walk up to her door and turned around and looked, and my car had burst into flames. You know, when I speak all over the nation, people yell out, yeah, hot date. Well, it's more like first and last date. Well, fortunately, I got involved with real estate, and it changed the rest of my life. So, just so you know, I'm not an attorney. I hired an SEC attorney, and I have for years, to gather the information that you're getting ready to hear. Let's go back in time. A little history on how these rules all came about. Well, the Securities Act of 1933 was when it started, and the goal was to protect lenders, investors, by requiring you, the issuer of securities. The securities mean it's an SEC term for asking for money, to disclose a significant amount of information about your company prior to raising funds from the public. So you have to provide them information, and the best way to do that is with a disclosure statement, and it needs to be provided to all your lenders, unless there's a qualification or exemption from registration on that. So the Regulation D was adopted in '82 from the SEC, and encompasses three what's called safe harbor exemptions. What that means is you can use these exemptions and be safe from advertising for lenders or getting lenders. It's Rule 504, 505, and 506, and these are all called Regulation D. The focus of today is on the 506, the specific safe harbor for securities exemption under Section 4A sub 2 of the Act, which really talks about private placement. The 506 enabled businesses to raise an unlimited amount of money from non-accredited or accredited investors. And I'll talk about what those are in just a second as far as accredited investors go. And I know going through this presentation, for some of you, you're going to be hit with some terms maybe you haven't heard. We've already been through a few of them. I'll try to explain those as we go through. While the securities, which means what you want, money from a private lender and what you're offering. Um, don't have to be registered with the SEC at times. The rule requires that the company provide all non-accredited investors with a disclosure document, namely a PPM. The bigger term is Private Placement Memorandum. Some of you might know that as syndication. I'm going to abbreviate with just the PPM term for this presentation. Now, the definition of an accredited investor is any natural person who earns more than $200,000 or $300,000 with a spouse in each of the prior 2 years and can reasonably be expected to earn the same amount in the current year, or, notice this is an or, not an and, or who has a net worth, excluding your primary residence, exceeding $1 million, either alone or jointly with a spouse. So if they're worth $1 million less their personal residence, or they make $200,000 a year, or $300,000 with a spouse, then they're deemed an accredited investor. Why this is important to the SEC? Well, because the SEC, when I talk to them, they say, our job is to go out and protect somebody from taking the life savings from the little old gray-haired lady. Well, if someone is worth $1 million or makes $200,000 a year in the eyes of the SEC, then they need less protection, and so therefore we can deal with them easier, if you will, if they are an accredited investor. The non-accredited would be the little old gray-haired lady that doesn't have $1 million in net worth and doesn't make $200,000. Well, sadly, even after spending an enormous amount of time and money it takes to prepare a PPM, I found that my students and businesses have not been allowed to advertise for lenders until now, and that's the big change. The SEC position historically has been that a general solicitation advertising. General solicitation means you run an ad and or you put it on your website to where everybody can see it. So general means general public. Solicitation means is advertising, soliciting for money. Is compatible with the definition of a private placement or private placement memorandum, a PPM. So they thought it was incongruent. So they resist this. But what happened was on April 5th, 2012, Congress forced their hand and enacted a law that would change this. It's called the Jump Start Our Business Startups, or the Jobs Act. Maybe you've heard about that. Well, a piece of this opened up the door for advertising. In Congress's mind, they wanted us investors to be able to be more successful in getting money to do our deals and thereby helping the economy. So Section 201A of the Jobs Act mandated that the SEC eliminate its general solicitation prohibition for private placement as long as all investors are accredited investors and the issuers, that's us, have taken reasonable steps to verify this fact. So on July 10th, 2013, finally the SEC commissioners adopted and amended to Reg D, Rule 506 of the Securities Act 1933 to comply with the new law. The amendment, which became effective September 23rd, 2013, defines two Rule 506's exemptions. We now have a Rule 506B and a 506C, and that's what we're going to dedicate the rest of this talk on. So what happened was Congress in 2012 told the SEC to go allow advertising. It took them over a year to adopt an amendment, and then that amendment wasn't rolled out that day. They rolled it out in September, but now it's active. 506B is really basically like the old 506 Reg D, which I'll explain a little bit more. But the 506 Reg D no longer exists. It's either a 506B, Rule B, or a 506 Rule C now. 506 Rule B, which is like the old one, allows for private placement to be sold up to 35 non-accredited investors as long as the investors are provided with a private placement memorandum and has as many accredited investors as you can have as many accredited investors as you wish. But it doesn't allow for any general solicitation, so you can't advertise. Rule 506D is now gone. 506B you still can't advertise, just like the old 506 Reg D. But with Rule 506C, you can advertise, and this is what people are getting excited about. This is the new kid on the block that I talked about on my very first slide. The new 506 Rule C allows businesses to use general solicitation to find investors as long as these two conditions hold true. One, all the actual purchasers of the securities must be accredited investors. These are lenders loaning you money. So they got to be accredited investors like I defined just a few minutes ago. The issuer must take reasonable steps to verify that every purchaser, every lender, meets the qualification of an accredited investor. So under the old rule, 506 Reg D, the issuer could rely solely on a statement from the investor as confirmation that he or she met the credentials. So all we had to do was ask the lender if they were an accredited investor. If they said yes, then they could loan us money. Now it's up to you to verify that a potential investor qualifies as an accredited investor prior to the offering the securities for sale. So it falls on you. This is still the case if you offer the securities for sale under Rule 506B, but then you can't advertise. So 506C provides a flexible, principles-based method of verification. Some factors to be considered by you. One is the nature of the purchaser. I'll explain that more in just a second. The type of accredited investor that the purchaser claims to be, whether a natural person, a corporation, a bank, or a trust. The Jobs Act requires that issuers wishing to engage in general solicitation take reasonable steps to verify the accredited investor status of purchasers. Now, I know these terms, once again, probably aren't used to, but I'd prefer in this presentation to use the terms that my attorney has given me, that the SEC uses. So if you're ever talking to an attorney, you'll be a step ahead. So I'm trying to help you. So issuers, anytime I say that, that's you. General solicitation is advertising. When I say investor, accredited investor, we've already talked about that. That's somebody that's got a high net worth. So I hope that helps you a little bit. Now, 506C sets forth a principle-based method of verification which requires an objective determination by you or somebody working on your behalf as whether the steps taken are reasonable in the context of particular facts, circumstances of each purchaser. In that case, it means lender, somebody's going to loan you money, and the transaction. I'm going to explain this more. The nature of the purchaser and the type of accredited investor that the purchaser claims to be. The amount and type of information that the issuer is about the purchaser, and the nature of the offering, such as the manner in which the purchaser was solicited. How'd you find him? And the terms of the offering, such as do you have a minimum investment amount? Now, the nature of the purchaser, the amount and type of information that the issuer has already acquired about the purchaser, such as a public filing. If the investor is a bank or a corporation, yeah, you can borrow money from them, or any third-party information that you got. The nature and terms of the offering, such as your minimum requirement, things like that need to be disclosed. The SEC also provides what is called a non-exclusive list. That means there could be more ways to validate that these people are accredited investors, but they've given us a little bit here of a list to verify the methods that you can use to ensure it meets the verification requirements when dealing with purchasers who are a natural person. So here they are. You might want to write these down. If you're going to work with accredited investors, you need to verify their income. You need to verify their net worth. You need maybe a third-party verification. Accredited investors in existing rule, many people already have, obviously, the 506 Rule D out there will now newly named 506B offering. So if you got accredited investors there, you got to go back and validate them. I'll talk about that. So you got to validate that they're really accredited investor, and that responsibility falls on you. Disclosures and filings, like Rule 506B offerings, Rule 506C offerings are exempt from registration requirements, but in contrast to Rule 506B offerings, a PPM document is not required. So what it's saying here is because everybody in the 506C are all accredited, you don't need to have a PPM. Now, I would probably have one, but the door is open for some of you. Since 506C offerings are sold only to accredited investors, there is no specific disclosure requirements. But you do have to let the lender know the particulars, and we'll talk about that, of your deal. You need to provide your investors with a general disclosure document that contains a significant amount of information such that the investors will not deem to be misled about the investment. And that's very important. Both false or misleading statements and omitting information with the intent to mislead is considered to be fraud, and you never want to be tagged with that. So for an example, if you fail to tell your investors that the real estate you're planning to invest the money on is located in Tornado Alley, you could be found guilty of fraud if the investor, if you lose money on the deal. Typical disclosure statements include this. You might want to write this down. Your business type, its operations, information about your team, your management team, potential risk investors face when they invest in money, and your firm, and the financial statement. One of the things I'd encourage you to do is this. Real estate is risky, and so you're better off, rather than telling your lender that everything's safe and all that, I think you're better off making sure that everything's laid out with the risk so that they can make an informed decision. The financials are not required to be audited in your 506C, but the numbers should be accurate. So your company numbers your financials ought to be true. If this is your first time through the process, I'd highly recommend that you get a securities attorney. Yes, it's more money, but it won't cost you nearly as much if you get charged with fraud because you didn't include a material fact. You will need to file a Form D with the SEC within 15 days of the first sale of the security. Now, what is this? Well, we're talking some different D's here. I started off with a 506 Reg D. Now I'm talking about a Form D. And I was confused with that when my attorney was talking to me about that years ago. Now I understand. 506 Reg D is the regulations that the SEC set up. The Form D is what you have to fill out and turn in. It's easy to do and it's free. Must be filed electronically. And you just go to sec.gov/about/Form D.pdf, and you can download it. So if you don't get all that, and you just go to sec.gov, sort around, search for it, you'll find it. There it is. There's what the top part of it looks like. So this easy form gets turned in when you're going to go find private lenders. It's filed out on the Edgar, EDGAR website. All Rule 506 offerings are exempt from state registration requirements under Section 18 of the Securities Act of 1933. What's that mean? Well, this is a federal rule. Remember, this Rule 506 is a federal regulation, and so the states can't trump it. Now, some states will require the Form D notice to be filed with them as well, along with if they got any minor fees out there, they might ask you to do that. Individual states, of course, can retain authority to investigate any allegations of fraud, just like the federal government can. So they have a little bit of leverage, but actually 506 trumps the state. Note that the Form D was revised when these acts were released here in 2013. It's still quick and easy to fill it out, but now you got to check a box whether you're going to use the B or the C under item 6 on the form. So just write down item 6. When you get there, you'll see which way are you going to go, and they just want you to check the box. Additionally, the form now includes a statement that your signature certifies that you are not disqualified from using either one of the rules due to a new exemption called Rule the D now, 506D, sub D. This rule, 506D prohibits covered persons associated with the offering who fit the definition of a felon or bad actor from being involved in 506 offerings. So what happens here is if somebody has been slapped with a cease and desist in the past, for an example, then they could be restricted from doing this offering. So let's talk about this. A bad actor is anyone who's been convicted of crimes involving securities, has been subject to some other form of court or SEC order pertaining to securities, has been suspended or expelled from membership in a securities self-regulatory organization, or has been charged with some other similar types of violation. If this describes you or any of your partners or any promoter that you employ, see the different levels here? In the capacity and time of the sale of security, you will have to apply for a waiver. So what that says is that even though you got somebody or you've had a problem, you can go in and ask for a waiver in order to offer the securities under Rule 506B or 506C. You'll need a waiver if the above description applies to any person who has received or will receive any compensation to solicit purchasers or lenders for your offering. If you pay someone to line up investors for you and that person meets the definition of a bad actor in the eyes of the SEC, your offering will no longer qualify for an exemption from registration unless you get the waiver, which is just one more hassle you don't need. So just be careful who you hire. Even if the person himself happens to be clean, if any directors, executive officer, general partner, or managing member of the firm which that person works has run amok of security laws, your offering can be disqualified. So typically the person has to have been associated with one of the disqualifying events within the last 5 or 10 years, depending on the event. In other words, if someone is associated with the offering, got slapped 12 years ago with a cease and desist, then the offering would not be disqualified because the statute of limitations on a cease and desist is 5 years. These bad boy provisions, as they are sometimes called, apply only to 506 offerings, both B and C, made after the effective date of the new legislation, which you know that now, what that date is. We covered that. There it is again. September 23, 2013. However, you are required to disclose any pre-existing disqualifying events to your potential lenders. So what I've just said here is with the SEC, you can move forward if you've had a cease and desist and it's more than 5 years old, but you'll have to provide that to your private lenders, your lenders. Let's compare the B's and the C's. B is virtually identical to the old 506 Reg D. The names changed slightly, and the bad actor provision that I just went through didn't exist in the old days, but it does now. So if you don't plan on using general solicitation and you want to, and here's the benefit, include non-accredited investors, then you can still use, you can do so under the 506B. So the point is, on the 506B, the big thing here is you got the bad actor rule. You can't advertise, but you can have 35 non-accredited investors. So for some of you, I know that's what you want to do. You just can't advertise, so you can do that. The table below here, what I tried to do was show you the similarities between the two rules and just kind of highlight them. So between the B and the C, unlimited amount of money, unlimited. So whatever you want, basically, then you can go get it. Filing requirements, they both use the Form D that we talked about. And as a subnote, some states might require a little filing and a little fee, but the Form D is free. You got the new bad actors restriction on both, and your folks can't resell the exemption. Now, 506B, no advertising, as you know. 506C, yeah, that's the one everybody's excited about. You can advertise. On 506B, virtually unlimited number of accredited investors, and plus you can have 35 non-accredited. But 506C, you're restricted accredited investors only. So star that, mark that down. 506B can basically rely on self-certification by accredited investors, but on C, you got to take reasonable steps to verify that the purchaser qualifies as an accredited investor. On B, you want to do the PPM, Private Placement Memorandum. C, they say that you can have a disclosure document not at the level of the PPM. Frankly, I think you'd be better off just doing the PPM. Once you've advertised for a lender in your offering, you are limited to being borrowed only from accredited investors. So once you advertise, you're on the 506C side. You cannot decide to opt for the 506B exemption and include non-accredited investors if you're offering after you've already advertised. However, if you checked the 506C box on the Form D, remember that item 6 where it had your choice? If you've gone in and checked 6 starting out, but you have not advertised in general solicitation, haven't done any advertising, then you can decide to go back and use the 506B. You just got to amend the Form D and abide by the rules and provide any non-accredited investors a PPM. That means you'll need to provide a significant more detail about your company than is required in a general disclosure statement, including audited financial statements. Because there are non-accredited investors, that's why. So they get more information. Your lenders get more information if you decide to do a 506B, but the plus is that you can have non-accredited investors. So the upside of the C is that you're all accredited. You got to verify that they're accredited. They get less information if you so desire. Let's look at the pros and cons on this. Thumbs up, there are 3 pros. You can advertise. Bottom line, huge. This is what everybody is looking for. They want to go out and they want to use this big hammer of PPM to be able to advertise. You get brand recognition that's going to come along with that. You'll have your name out there because you're advertising. And you avoid the time and expense of preparing a full-blown PPM. Now there's some cons. There's some additional cost in verifying that your purchasers qualify as accredited investors, the time to review the forms that your potential investors supply you as documentation, so that's going to eat up some of your time. And you will need to fully scrutinize the documentation to ensure that they meet the criteria of being net worth of $1 million and make $200,000 a year. Those 2 areas, one or the other. Some investors may decide not to invest rather than provide you with the financial information. Maybe they don't want to give it to you. You will also need to learn to comply with numerous privacy laws that have been enacted. So take specific necessary steps to protect the sensitive documents, limit access to documents, avoid using unsecure cloud-based storage systems to store electronic documents, establish a system whereby any sensitive documents are destroyed once they are no longer needed. So it's just talking about on the front end here that you need to have your act together to protect the confidential information, just like you'd want your information protected if somebody else had it. Establish a system whereby any sensitive documents are destroyed once they are no longer needed. This just all takes time and money, much more than is necessary to review the self-certification statements from accredited investors when using the 506B. Caveats? Well, integration of the new 506C offering with the previous 506 Reg D offering requires that you go back to your 506 Reg D investors and verify that their status as accredited investors. Worse, if some of your 506 Reg D investors do not meet the qualifications, like they're not accredited or things have changed, it can cause you the entire offering to lose its exemption. Remember that safe harbor thing? The problem usually arises in offerings that are within 6 months of one another. It's just best to consult with an attorney if there's any risk on this happening in your particular case. Could be new changes. This is new, and require the 506C issuers to file a Form D within 15 days prior to any general solicitation, to asking for everything. Require an additional Form D to file within 30 days when you're done, when you want to cancel the offering. This rule may also apply to 506B offerings. Require filing an updated Form D every year. As long as your offering's open, you file the Form D every year. When you're done with this offering, then within 30 days, you file it again to close it out. Require specific legends and disclosures in general solicitations which you'll be given. Increase the amount of information that needs to be provided on the Form D. Modifications of the accredited investor income and net worth qualifications include financial sophistication requirements for accredited investor qualifications. Restrict content of general solicitations are some of the things that they're considering. So just know that there might be changes down the road, but there could be on anything, couldn't there? So you just have to comply with the new rules. And let's see, from using both 506B and 506C exemptions for a period of 1 year from the point in which the non-compliance. So if you're tagged as being in non-compliance, then you can't go out and use 506B or C for a year. If you happen to get caught up in your real estate business and neglect to file the Form D within the specified time frame, Rule 506B and 506C offerings will be off the table for a year. So pay attention to those timelines. In fact, wouldn't it be better just to file the Form D prior to getting any money? Not, you got that window of 15 days afterwards, but what you're saying is you miss that, then you're done for a year. Those changes I just ran through real quick, they're not law yet. The ones I ran through here in the last 2 minutes. And they're getting a flood of negative feedback that the SEC has received some of these, so some of them might not make the cut. You just need to keep informed, and that's one of the nice things about working through an attorney, is if there is a change out there, they know where to look. Let's talk about 6 steps on making you a winner and successful on a 506C offering. Here's step 1. See my arrow up in the right? Number 1 of the 6. Make sure you got accurate and up-to-date financial statements from the folks. Your potential investors, your financials. Make sure you got accurate financial statements because they might want to see them. Also ensure that there is no bad actors involved in your company that can cause you to be disqualified from the 506. Establish a system to ensure that security of the sensitive documents like we talked about that you're going to receive from your potential lenders. Verify their status as accredited and include how and when you'll be purging documents that are no longer needed. If you have executed a 506D offering and a Reg D in the past, now called the 506B offering, within the last 6 months and have sold some of your securities to non-accredited investors, you should check with an attorney to determine the risk that the 2 offerings will be integrated, disqualifying both from the exemption. So you don't want that to happen. Number 2. No specified documents, disclosure documents for the 506C. Anti-fraud laws mandate that you provide investors with significant information to enable them to judge the risk of the investment. So you got to provide them information, but you don't have to do it at the level of the PPM. At all costs, avoid blatantly false or misleading statements and do not attempt to mislead. Your disclosure should emphasize that the offering is being extended to accredited investors only. Hire an attorney to help you with this part, particularly if this is your first introduction into disclosure statements. Regardless, be certain your documents look professional. Now, maybe you are a securities attorney and you can handle it, but if you're not, I'd get some help. Step 3. Decide what venues you'll be used to market your securities. TVs, newspaper, personal website, luncheons, internet. Once you made this decision, you'll be in better position to prepare your marketing materials. And go back and read that last statement again about getting an attorney on step 2 there. All right, more on step 3. You want to provide brief description of your company, the type and terms of the offering, And be careful not to make any promising regarding future performance. For an example, a statement such as you can expect to earn an annual return of 10% on your money if you invest with it is a major no-no. So nothing about future earnings. In fact, if you include any historical performance figures for your company, you're going to need to put in a warning line. Many of you have already seen this on other investments. Past performance is no indication of future performance. Consider hiring a securities attorney. Well, you heard me say that a few times, right? Here's step 4. Time to do the Form D. From the SEC website and submit it electronically as instructed on the form. That's at Edgar website. That's Edgar. You saw me hit that quickly. Determine what state law is in all the states which you're intended to solicit. So you could have some minor changes as you work in different states, and so just be aware of what's needed within each state. So you just ask ahead of time, figure it out. And what federal law pre-exempts states from requiring you to file a registration when the 506 offerings are involved. Individual states can mandate you to provide them with a notice filing, and you check if there's any fee. So things we've talked about before here. Although you don't have to file a Form D with a federal SEC until after you sold your first security, you got a 15-day window to do so. Yeah, I'd recommend, and it is recommended by my attorney, that you do it sooner rather than later. You know, you'll be busy enough once the investors show an interest in investing in your business, and some states may require that you file them even before the first sale. So that's another little thing about the state. You could have a form, you could have a fee, you could have to file the form before you make your first sale within that state. Number 5, potential investors are likely to balk when you ask them to supply you with personal financial information like we talked about. So you need to take some time to decide the best way to approach them. If you've already established a procedure for ensuring that the information that they provide is protected, and like we talked about in step 1, you can note that when you ask them to submit their paperwork, and that will give you a little bit of edge that they know that you've done your homework. Your professional approach could impress the documents right out of them without them complaining too much. For someone that has been an investor before and an accredited investor, you know, they're not used to providing those documents. And so when you go to them, they might dig in a little bit and wonder, and you just got to explain that the rules changed. Just be prepared for some potential investors to bluster and feign offense at your request, providing you with a number of reasons why you should accept them on their word. Well, just don't do it. You know, this might occur quite frequently initially, since the purchaser of the private placements have been able to self-certify, just like I talked about in the past. Don't take it personally, and don't take their word for it. Remember where the buck stops. It stops with you. Maintain good records. Number 6, our last item. Record everything having to do with the offer, and keep your paperwork in order. Keep copies of your offer, your disclosure statement, your marketing material, your request for their financial information, anything you've submitted to the SEC. So there's a 1, 2, 3, 4 places to hit on this one. Remember to document the method you use to verify each purchaser as an accredited investor. I'd write that down. Although maintain good records is always important, it may provide especially critical when using the 506C, which are all accredited investors. This new rules allow for something unprecedented in the world of private placement. Because of this, it's highly likely that the SEC is going to be examining these types of offering with a magnifying glass. So just be prepared. Well, in summary, the new enacted 506C, which has my students all excited because you can now advertise, enables you to advertise for investors by any number of means: newspaper, magazines, public websites, communication broadcast over TV and radio, seminars where attendees have been invited by general solicitation, or, you know, if you're going to do a luncheon, if you're going to do a Qantas Club, you can get out there and tell them and general advertise. In addition, the use of any unrestricted and therefore publicly available website constitutes a general solicitation. So if you're a 506B, you can't put it on your website. If you're a 506C, then you can. You can general solicitation, you can advertise. You can use any and all of these methods to find private lenders and still be exempt from both state and federal registration requirements. Remember that you do have to verify that all your limiters qualify as accredited investors. However, you cannot simply have them sign a statement as they have in the past. They need to provide you with actual documentation. You got to keep it on file. You got to keep it secure. And then when it's over, you got to destroy it. And if you have partners or plan to pay somebody to help you, make sure they aren't a bad actor. But if you will not have to bear the cost of both time and money of preparing a PPM on that one. So now what? Well, I'd recommend that you get a system that others have used to amass millions of dollars in PPMs, a very simple and easy to use system. It's my home study system, the Private Placement Memorandum system that I created on how to raise a ton of money. It's essentially a private placement money manual. It has a new chapter and audio on the 506C, how to prepare a private placement memorandum that spark investor interest while keeping you in SEC compliance and protecting you. What every real estate investor must know about the SEC, Regulation D, and staying in compliance. You cannot hope to succeed as an investor without knowing this. The SEC rules about PPMs are here. Here's what you need to know to ensure you stay in compliance. Who is accredited investors and why they're so important to your ultimate success, and how to find them quickly and easily. How to create a comprehensive transaction structure step by easy step. The required contents of the PPM. You may be genuinely surprised at what needs to be included to ensure your protection, and how to properly display your distribution of your PPM when a private offering becomes a general solicitation, and why it's so important to your ultimate success. It answers all the most commonly and many not so commonly asked questions about PPMs. So if you have a question about PPMs, chances are it's answered in the manual that I've created. There's 7 rules governing the limited offerings in the sale of securities without registration under the Securities Act of 1933. It has terms and definitions that you're going to need to know in dealing with attorneys and PPMs. You go into an attorney and they start throwing some of the terms that I've given you today or more, and you're clueless, and they're talking over your head. You don't want that to happen. You want to be in there and be on the same ground on the terms, so that you know exactly what's going on. The cool thing about this system is in this I have put a PPM template. Now here's the goal of my system. The goal of the system is to get you out there creating your own PPM to start with. Now I would turn it over to an SEC attorney to finish it, but think about the cost that you would save with this. So what I've done is I've got a template in there for you, and once the template is done, then it's time to contact the SEC attorney and finish the job. So here's the deal. The system walks you through how to create your own PPM. It gives you in-depth knowledge of creating that PPM. And these attorneys, their pricing is all over the map. I mean, gee whiz, they can charge $25,000 for a PPM, whatever they want, $50,000. A lot of those are big corporate guys, $100,000. Big corporates. But for us, real estate investors, we aren't going to pay that kind of money. We want to be down at the other end. So typically I see people paying $15,000, $10,000. The lowest that I've seen is $6,000. Well, what happens? Let's say somebody out there is going to charge between the let's say they're going to charge between the 6 and 10. Let's say they're going to charge $8,000 for the PPM. You walk in there with your PPM already done, hand it to them. They got to cut the cost. They aren't getting paid to create that whole thing. You just took half their job away, And plus, there's 6 dynamite audios. The PPM audio library comes with this 6 audios. The new one is the one on the 506C. Plus the forums out there. There's one on the accredited investor status questionnaire, certification of formation, certification of organization, sample operating agreement, sample private placement memorandum, the template we talked about. What would you have to pay to have all the money that you could need, or have somebody create a PPM for you? Let's say an attorney out there for $8,000. Let's say rather than half, like I talked about a second ago. Let's say it saves you 30% savings. That's $2,400 off the $8,000 PPM. You know, if you got one that's 10 or 15, well, you know, the 30% just tracks with that. I think you can save more than that. Would make sense to me. But on this example, that means that you'd only have to pay $5,600, less than the $6,000 I talked about a second ago. So walking in with this, plus if you got a $6,000, that, let's say that one comes down a few thousand, that one should come down a few thousand too. Well, the real world value of my private placement memorandum system, the home study system, the 6 audios, and the form CD is $997. I'll tell you what, it cost me a tremendous amount of money to create this thing. But once I got it done, I had a great system for you to invest in. Just think of the possibilities of having this. It's the knowledge. That's your biggest benefit. You will have an in-depth knowledge of your own PPM. Not that you turn it over to some attorney, they did it, and then you get it back and you aren't sure what's inside of it. You will have the advantage when hiring an SEC attorney because you can talk their terms to them. You will have the advantage of finishing the PPM by turning over to an attorney and getting it done because you've already got it all set up and you'll know what it takes to finish it up. You'll avoid being taken advantage of by your attorney, and future PPMs will be a cookie cutter and additional savings for you. What happens is somebody gets out and they do one deal. Let's say you're going to do a 40-unit apartment complex and you got a PPM to do that. Well, the next thing I know is once you've done one, then you want to do 2, 3, 4, 10. Well, once you've done your 1 PPM, then you got your template, your cookie cutter, and think of the savings of creating your next one. You don't have to pay $10,000 every time you've got a PPM. You can get a reduction in that because you've already got it done. Bonus number 1 is I'm gonna reduce the price. I'm gonna take $200 because I want you to get it immediately. I want you to get it right now, rather than paying the $997, which is on the website, which other folks pay. Right now, I'm going to take off $200 for $797. Think about that. Would you pay $797 to save $2,400? Think about that. Think of this, and then the cookie cutter, doing it over and over and over again. Hey, I'm going to give you a bonus. Bonus number 2 is, how about a hot list of private lenders? This list is updated every single month. You click on that button up there on the top left. You sift and sort all you want. You can save the searches. You know, and then on the second box on the right-hand side, see where you got a mail manager? You can mail them. We've already got a letter done for you. You can go in there. You can target a state, target an area, mail letters to the folks in that area. These people are already private lenders. Go for the people that have loaned big chunks of money, most likely the accredited investors, right? If that's what you're looking for. And then you click over there. Now, there's a little added cost on that mail service, but my gosh, well worth it. Now, on this site, it is free for you to do a test run on it for 3 months. After that, there's a small fee. My recommendation is don't trigger it until after you get your PPM done and you're ready to go seek out private lenders. Then trigger this. Then you got 3 months for free. You might already have enough money at that time where you don't need to use it again. I'm going to limit the number of folks that can get their hands on this hot list of private lenders to 17. I want to work with people that take action, so when you see the website come up where you can order this and invest in it, I want you to jump all over it. We talked about the Form D. Bonus number 3, I'm going to give you one of my newest ebooks on Form D. You will love this. It tells you about the acre site. One of the things I like about this ebook is the fact that we did screen prints and step-by-step how to file the Form D. It's been updated for the new 506C, 506B regulations. Next bonus. This is the 3-touch rule system that I created on prospecting for lenders. What's the 3-touch rule? Bonus number 4. Well, this is where we found with you folks that are going to be using the 506B where you can't advertise. Well, how do you get the word out about this? Well, my attorney researched the SEC and they found out what the difference was between a stranger and someone you've got a prior relationship with. So if you got a 506B, you're working with people you got a prior relationship with, people that you know. Well, what happens is after 30 days and 3 touches, then you can work with the folks that were strangers to start with, and now you've moved them down into where they are considered the prior relationship in the eyes of the SEC. I created a full-blown system on how to administer that, because I don't want you to nuts it up. I don't want you to do something to stub your toe. This gives you the rules. It gives you the holding a meeting with the folks, a training. It talks about 15 pitfalls, critical follow-up steps, and I give you the tools for that also in the follow-up. I do a PowerPoint slide presentation, and I include in the manual, which is what I'm talking about on this chart, I include my talking points on every slide. On the Form CD, I've got a luncheon checklist. I got a webinar checklist. So if you want to create a luncheon, here's a checklist. I got a postcard that you can mail out. I got a newspaper ad, a Craigslist ad, and 2 special reports. The special reports are for the follow-up, for IRA and people with CDs. Plus, I've got 3, not 1, but 3 PowerPoint presentations. I've got one that's 56 slides long, and then I thought, we've got to get to these 3 touches. How about if I take that PowerPoint presentation and split it up to where you got 26 slides and then another one for 26 slides, like part 1 and part 2. And so you can decide to go and do the full boat, do the whole slide presentation, one meeting, or you can do part 1 and then they come back a week later for part 2 and you're working on your 3 touches. Then you send out the special report for IRAs that I created. It's all done for you. Everything is done for you. It doesn't violate any SEC rules. It's pure investment training. And that's the key here. In the educational luncheon, the 3-touch rule, you are not asking for money until you get past 30 days and 3 touches. You got 4 incredible audios. They cover everything on how to prospect and stay safe. We talked a lot about general solicitation. My attorney has never done a better job in defining what that is than what he did in these audios. And here's what he said. He said, frankly, I believe these to be the best audios I've ever done. 3-touch rule value is $497. Digital delivery. Here again, it's just for the first 17 folks that jump all over this. Don't be left out. You also get this home study system, a $497 value. I'm going to include my boot camp. This is an alumni picture. The guy there on the right with his knee down, you see him on Flipping Boston. He's TV star. He's come there to learn how to get private money before he got on TV, and now he's out rocking and rolling, using private money to do the deals. I'd love to see you in one of these pictures. So you get to come to my boot camp. I'll train you on the best, safest, easiest way to get private lenders you will ever need. I call it my roadmap to success. In every single boot camp, my students have acquired private lenders. Listen to that. In every single boot camp, we acquired private lenders. How much? Well, over the life of my event, which started in 2004, we raised over $500 million in the first 24 hours. I cut the clock off on day 2 at lunch, and as the boot camp goes on, it's a 4-day event, I'll take a break. Somebody will come up and say, hey, I just got another $200,000. A little while later, somebody else say, hey, I got another $400,000. I'll tell you, by the end of the event, they're loaning each other money. It rocks. So there is nothing else like this on the planet where people raise money at the event and multi-millions of dollars in the first 24 hours. What you'll learn is I bring my SEC attorney in on day 3. We go over pooling money, which you can do with your PPMs, SEC do's and don'ts, SAFE Act, IRA money, how to get the money to a closing table. We do a role play on how to ask for money, the anatomy of deals, and buying commercial property, no money down. If you want unlimited dollars, advertise and pool money, come to the event. We'll show you the way. You get great training on answering lenders' objections. It's the key to getting money. I'll even tell you what to say if they ask you about Bernie Madoff, one of the most hated mans in America. You get 30 minutes free with my SEC attorney after the event. I'm going to give you a website to go here to in a minute, and when you go there, I'll have my upcoming events on there, so you'll know right when you can come this year. I do 3 of these a year. You can start any time. If you can't make the next one, well, you just come to the one after that, and then you can come back forever for free. This event, people have paid $4,995 over the years on that. In fact, I had 2 folks from Australia show up and come to the event. Typically, people from Canada are there. This thing rocks. It's free for you folks. You can bring a family member for free. You get a fabulous boot camp manual. It says come back for a year here. I just changed that on you. You can come back forever. A CD-ROM of forms, tax deductible, and you get a graduation certificate. That adds up to $8,990 on that slide. Plus, I give away stuff. Down there at the bottom, you see I give away over $5,000 in prizes. I typically give away a laptop. Last event, I gave away a GoPro video camera. Just rock. Super bonus number 6. You get free upgrades for life in the Private Placement Memorandum Home Study System. Here's a breakdown of the offer. I know I went kind of fast. PPM is $9.97 on the website. You got $200 off of that. Here's a ton of bonuses. The hot list of private lenders. I saw somebody else charging that for it. The 3-touch rule, the Form D. My lifetime upgrades is priceless. The boot camp. That's a total of $8,524. You get it all for just $797. Incredible. Ironclad money back guarantee. You know, you can, if you decide to return the PPM manual system and the audios and the form, you can keep all the other bonuses, the Form D book, everything else. You can keep it except for the boot camp. Why? Because you got to have the tools to come to the boot camp. So all the risk is on me. Ironclad money back guarantee. You got 7 days to check it out once you get your hands on it. If it's not for you, you get a prompt and courteous refund. I want you to be happy, obviously. Look, you got 3 options. Option 1 is to do nothing. What are you going to get when you do nothing? Well, you get nothing. Option 2 is do it yourself. Well, that'll be the hardest way to do it. There's no way you can match the value that I just gave you in this, plus all the bonuses. Or embrace my system, take action, and go to the site I'm going to give you right now and get involved. Go to www.allensoffer.com/ppm. Well, that would make sense, wouldn't it? Private Placement Memorandum. The page again is Allens. My name is plural in this case. ALANS offer, OFFER.com/ppm. Go there right now and don't get locked out. Or you can call 800-584-3346. I got friendly operators standing by 24 hours to answer your call. 800-584-3346. Write that down. Some of you are chomping the bit wanting to know about the free gift. Here it is. It's one of my newest ebooks on cease and desist. Remember we talked about cease and desist early on? I thought, well, what a better way to give you guys a tremendous little gift here. My ebook on cease and desist. Brand new. You're going to love it. You need to know the insides and outs of the cease and desist, what it all means. There's stuff in there I'm sure many of you don't even know, and you ought to get it. How do you do it? Go out to the site. I got it out there for you. You get it as a free download. You people that are investing in the PPM system, it's already set up. You don't have to click on that second button. Click on the button to buy, and I will send you the ebook in that. Plus the other one, the Forms D. allensoffer.com/ppm. Or go to 800-584-3346. Look, folks, let's be candid. Let's say you're on this call and you're just starting out in the real estate business, and you're thinking, I don't know if I want to do a PPM, or I don't know where my business is going to go. I'll tell you what. You want to get your hands on this tool for a number of reasons. One is you got a boot camp, and my boot camp rocks. And so you come to that event. The PPM manual you have in your hand, you start building your document, your PPM, and then when you're ready to pull the trigger and go out and buy that big 40-unit apartment complex or office building, or in fact, you can use this for residential. Some of you folks live in areas that got high-priced houses. You can use this to purchase those high-priced houses. This is the big hammer in the industry. In the whole industry, it's the PPM that gives people the leverage. What do you think these people that you hear about, the Donald Trumps of the world and folks like that use? They all use PPMs, exactly what we're talking about. This is it. And you're going to get the new information. You're going to get the one that's got the 506C that everybody's been hungry about to learn about. Get out there, get your hands on this, get the tools to get the job done. The audios are incredible, especially the new one on the 506C. There's a chapter in the book on the 506C. The book also has a number of forms on the form CD to help you out and give you the tools, plus the template out there. And I'll tell you what, this thing, there's nothing else out like this in the industry. And at this price, people are telling me I'm crazy to offer it at $997. They're saying people ought to be paying a couple $1,000s for this thing. So hop out there, go to allensoffer.com/ppm. You got nothing to lose. You got 7 days. Once you get your hands on it, check it out. Not for you, you get a prompt and courteous refund. Keep all the bonuses except for the boot camp. Or call 800-584-3346. I'll tell you what, this has been a pleasure. Love having you on this training. And if nothing else, you learned some terms you probably never heard of before. But I'll tell you what, every one of you out there ought to get your hands on this system because it is incredible. It's incredible. Well, to your wealth.